Hello everyone, welcome back to my channel. In this video, we will discuss the exemption or conditional removal of certain articles covered in sections 133 to 140 of the National Internal Revenue Code. Once again, I am your lady lawyer, Attorney Maria Cecilia Oliva, CPA, part-time lecturer of the Davao del Sur State College. Get your pen and paper, and let's begin. To recall from the previous video, we learned the classifications of excisable articles: alcohol products, tobacco products, petroleum products, miscellaneous articles, and mineral products. There are times when, in manufacturing tobacco product, one of the raw materials needed is a derivative of an excisable article, alcohol. So, if you were the manufacturer of this tobacco product, an excisable article, needing another excisable article as raw materials, you would want to mitigate the cost of that raw material so as not to further increase the manufacturing cost of your tobacco product. How do you do this? You may use denatured local and imported wines and distilled spirits to treat the tobacco leaves of your cigars or cigarettes. Apply for a permit for this purpose from the BIR Commissioner. You also need to specify in the application the quantities and grades that you will use to treat the tobacco leaves for your products. Once the BIR Commissioner issues the permit, the denatured alcohol that you will use for the production of your cigar and cigarette products now enjoy an excise tax-free status, effectively decreasing the cost of your raw material. What about domestic denatured alcohol? Can it enjoy excise tax-exempt status even if it is not used in the production of cigars and cigarette products? Yes, domestic denatured alcohol not used in the production of cigar and cigarette products may still enjoy excise tax-exempt status subject to the following requisites. Number 1. The domestic alcohol must be at least 180 degrees proof or 90% absolute alcohol. Number 2. It must be denatured. To denature is to destroy the characteristic properties of the alcohol. And number 3. The denatured alcohol must be rendered unfit for oral intake. For domestic denatured alcohol, even though that it is exempted from excise tax, it is not exempt from the value-added tax. If the denatured alcohol is used for motive power or the energy to drive machinery, even if it has the requisites for excise tax exemption, it will be subject to excise tax now for being classified as manufactured oils and other fuels. What happens to denatured alcohol which subsequently became fit for oral intake due to fermentation, dilution, purification, mixture, or similar process? If that is the case, the said alcohol shall be subject to excise tax, its classification now being distilled spirits under the NIRC. Whoever is in possession of this reprocessed spirits shall be the one liable for the payment of the excise tax. Any person who produces, withdraws, sells, transports, or knowingly uses, or is in possession of denatured alcohol, or articles containing denatured alcohol in violation of laws or regulations shall be required to pay the excise tax, in addition to the penalties imposed under the NIRC. As for petroleum products, they are typically subject to excise tax unless they are sold to any of the following. 1. International carriers of Philippine or foreign registry on their use or consumption outside the Philippines, under the condition that the petroleum products sold to these international carriers shall be stored in a bonded storage tank and may be disposed of only in accordance with the rules and regulations. 2. Exempt entities or agencies covered by tax treaties, conventions, and other international agreements for their use of consumption, provided that the country of said foreign international carrier or exempt entities or agencies exempts from similar taxes petroleum products sold to Philippine carriers, entities, or agencies. And 3. Entities which are by law exempt from direct and indirect taxes. What if you are a manufacturer of spirits like whiskey, are you allowed to transfer or remove your whiskey product to another facility to have it rectified. Before you can do so, the excise tax on your rectified whiskey must be paid for. But you may opt not to prepay the excise tax on this product by filing a joint bond with the rectifier, and such bond is conditioned upon the rectifier's payment of the excise tax on the rectified whiskey. In cases where alcohol has already been rectified either by original and continuous distillation or by redistillation, no loss for rectification and handling shall be allowed, and the rectifier shall pay the excise tax due on such losses. What if you are a manufacturer of fermented liquors like beer? Are you allowed to transport or remove from your brewery your beer products? Yes, you will be allowed to remove your beer products from your brewery or any place of manufacture to a bonded warehouse used by you exclusively for storage or sale in bulk of your fermented liquors. However, the amount of fermented liquor to be transported or removed must be at least 1,000 liters at one removal. You must also secure a permit from the Commissioner of the BIR before the transport and removal. This permit will allow you, the manufacturer, the privilege of removal or transport without having to prepay the excise tax on your products. After the transfer or removal, you, the manufacturer, must pay the excise tax on those products. What if your fermented liquor, like beer, became sour or damaged and is deemed unfit for use? Can you sell them? Yes, you can sell them, but there are conditions. First, secure a special permit from the Commissioner of the BIR to remove the damaged fermented liquor. Second, you must use a cask or package that is distinct from those ordinarily used for fermented liquor. This packaging requirement will ensure that the damaged liquor is easily distinguished from the good ones. Third, the cask or package containing the damaged liquor must have a note of its contents permanently fixed on them. Finally, each cask or package must contain at least 175 liters of damaged liquor. Once you meet all of the requirements mentioned, the removal of the damaged fermented liquor will not be subject to excise tax. What if you are the manufacturer of tobacco products, and these products are deemed unfit for chewing or smoking? What can you do? You can have them removed pursuant to the rules and regulations set by the Secretary of Finance, and its removal may be for agricultural or industrial use, free of excise tax. Stemmed leaf tobacco, fine-cut shorts, the refuse of fine-cut chewing tobacco, scraps, cuttings, clippings, stems, or midribs, and sweepings of tobacco may be sold in bulk as raw material by one manufacturer directly to another without payment of excise tax, under such conditions as may be prescribed in the rules and regulations prescribed by the Secretary of Finance. This ends our discussion on exemption or conditional excise tax-free removal of certain articles under the NIRC. Our next discussion will be the excise tax rates on excisable goods.